The 10th Annual Public Defenders Justice Summit. I'm very excited about this next panel. For many, many years, we've talked about bail reform and the need for a new way to determine who is released from custody. Right now, it's all based on the size of your wallet. If you have the money, it doesn't matter what the charge is. You can get out of jail if you have the price to pay. With evidence-based practices, we're beginning to look at bail in a new way. In fact, in San Francisco now, I'm sure Sheriff Mirkarimi will discuss this, that we have most of the people who are in jail are there because of pretrial detention. These are folks who haven't been convicted of a crime but are only in jail for the most part because they don't have the money to post bail. So the moderator for this panel is Chief Attorney and former Supervisor Matt Gonzalez, and look forward to this panel and their wisdom.
Thank you, Jeff. The reform of the commercial bail industry is becoming one of the most hotly debated criminal justice topics. Critics of the bail system, such as the Justice Policy Institute, have called the money bail system a failed policy that does not protect public safety and leads to excessive incarceration in local jails, mostly of pretrial detainees who cannot afford to buy their freedom. However, those in the bail industry counter that time and time again commercial bail has proven itself the most effective form of pretrial release, with those released on surety bond 64% less likely to become fugitives. Let me introduce the panelists today. Vera Robles DeWitt is president of the California Bail Agents Association. She owns Carson Bail Bonds and has been in the bail industry for 4 decades, and she is a former mayor of Carson, California. Catherine McCracken, Director of Policy and Development for the Center of Juvenile and Criminal Justice. She has presented expert testimony to the Little Hoover Commission regarding sentencing reform in 2012 and currently serves on the San Francisco Sentencing Commission. Ross Mirkarimi is the Sheriff of San Francisco. Previously, he served 2 terms on the Board of Supervisors, where he championed public safety reforms and worked closely with the Sheriff's Department, which he now leads, to modernize rehabilitation programming for violent offenders. George Gascón is the District Attorney of San Francisco. He has over 3 decades of experience in law enforcement, including his former role as Chief of Police of San Francisco. As District Attorney, Mr. Gascón has been a critic of current models in the criminal justice system that rely too heavily on incarceration. Will Leong is the CEO of the San Francisco Pretrial Diversion Project. The organization has evolved over 3+ decades to include programs ranging from fine alternatives and rehabilitative programs to more comprehensive case management. And finally, Jonathan Simon is Bolt Hall's Adrian Cragen Professor of Law. He teaches courses on criminal law, criminal justice, law and culture, risk and the law, and socio-legal studies. His books include Poor Discipline, Parole, and the Social Control of the Underclass, 1890 to 1990, and Governing Through Crime, How the War on Crime Transformed American Democracy and Created a Culture of Fear. Let's welcome our panelists. Welcome. I'm going to start with Catherine McCracken. Your organization, the Center on Juvenile and Criminal Justice, has done extensive research on the bail system and pretrial detention. Is the system currently working, would you say, and what reforms would you support?
Well, thank you for having me here today. The Center on Juvenile and Criminal Justice has released a report late last year that did examine the bail industry, particularly around the lobbying efforts. I want to kind of talk a little bit about the criticisms of the commercial bail industry that have kind of been reoccurring over the years. And these date back as far back as to the 1920s, that the commercial bail industry doesn't ensure public safety and that it discriminates against those that can afford to post bail. This is particularly important right now in California when we're in an era of realignment where counties are now responsible for an increased number of offenders at the local level. And so we have to really look to better utilize our jail space and make sure that the individuals that are confined to our jails are the ones that need to be there. Because many counties in California are under federal caps, so when the time comes, they just have to release inmates, and that's not really based on any kind of systematic way. Some counties are just releasing the first one in, first one out. And so some of these criticisms about the bail industry is that it doesn't really address the, affects individuals who are not able to post bail, are not afforded the kind of same due process as other individuals, that it can affect their experience through their trial. So, for example, individuals who are unable to post bail or in custody during the hearing trial process are attending their hearings dressed in their county issued blues. They're also potentially in attending hearings in handcuffs. And this can really affect the perception that jurors have on these individuals. Additionally, the commercial bail industry, the folks that are not able to post bail, are affected through collateral consequences by being potentially unnecessarily detained if they do not oppose a risk to public safety. So they are, affecting their ability to continue with their employment, education, or family responsibilities. So the Center on Juvenile and Criminal Justice would advocate for an increased use or implementation of pretrial services at the local level, and I'm sure some of the other panelists will speak more in detail about that.
Let me ask Ms. DeWitt, you're obviously a part of the California Bail Agent Association, the president of the organization. You have decades of experience. Critics have argued that your association and other associations like it use their influence by way of lobbying to protect the group's financial interests. I'm wondering if you could respond to that and perhaps give us an idea of what kind of lobbying your organization does.
Yes, thank you, Matt. First of all, let me thank Jeff ADACHI and the San Francisco Public Defender's Office for this 10th year of the Justice Summit, and thank him for inviting the bail industry representative. I am a last-minute substitute, so I don't have a prepared speech, but I do want to address some of these misconceptions. First of all, there is bail reform, and our industry is part of the bail reform. We are proud to say that we work with our regulatory agency, the Department of Insurance, to improve the standards for new bail agents coming into the industry. But alongside with that, we are not one-size-fits-all industry. Pretrial has a place at the criminal justice system as well as the commercial bail industry. And some of the misnomers, I'm glad that now we've been invited, we've testified along with Catherine with the Little Hoover Commission. Our lobbying efforts are basically, this is what we look like. This is the lobbyist. We're not high paid. I represent the mom and pop businesses, the small businesses throughout the state of California. And certainly, although hopefully our surety companies employ their lobbyists to preserve our industry because we are important to the system, this is what we look like. So it's not the typical that you see in the movie screens, Chico's bail bonds or a cigar and a pinky ring, diamond pinky. We're mom and pops, and the majority of our agencies are owned by women. So I want to at least have the opportunity to say what we're like and what we're doing. Bail reform, yes. We think one of the issues coming before the state legislature this year is, well, the Little Hoover Commission, as well as looking at the high cost of bail, that we're there advocating that maybe there needs to be a closer look at that. Yes, it has to be locally controlled, but we have nothing to do with this. This is the judges that set the bail. But I'm from LA County, and let me tell you, bail schedules are very high over there. But we work with our clients. We work with the families. We work with the co-workers. We work with the employers that want that defendant out of jail so they can continue to be a productive members of society while their case is pending trial. And just one last more thing I may not have an opportunity to on the soapbox, is the issue of well, the pretrial is there's a misconception about which is fair, which isn't fair. I have to say, for the sake of public safety, we do offer a little bit the results of the BJS study, that our statistics are better, is true because we incorporate other people with a part of the skin in the game, if you will, the families, the members, and we do a better job of seeing that people return to court. We don't judge, we just return them to court and make sure they make their appearances.
Mr. DeWitt, I'm wondering, you know, there are a lot of organizations throughout the state that, you know, kind of pool their resources together to be able to engage in some lobbying. I think that's probably true of small business associations. There's probably even some lobbying by the California Public Defenders Association and District Attorneys Association. Do you know how much money your organization spends on lobbying?
My association, again, is the mom and pops. We don't even have a paid lobbyist. But the surety companies, there's no way of knowing. There's about 9 or 11 surety companies that are in the state of California. I have no idea what their figure would be.
Now, are you, I understand you're also a member of the American Bail Coalition. That's the national group?
Well, let me explain. The American Bail Coalition is the representative of the surety companies. Those are the big guys that we get our paper to write with, but I am not a member of the ABC Coalition. That's only for surety companies. Okay,
and the Golden State Bail Association, is that a competing group to the one that you lead?
Yes, they've been around for about 10 years, and California Bail Agents Association has been around for 32 years, but we are colleagues and we share mutual goals.
Let me move on to Sheriff Mirkarimi. In 2010, 71% of California's county jail population were those who were unsentenced and awaiting resolution of their cases, so 71% of county jail inmates. The national average was 61%. I'm wondering if you can tell us, if you know, what the percentage is in the San Francisco County Jail, and then I'm wondering if you might say something about a sheriff's powers to affect the or control the pretrial population.
First of all, thank you to Public Defender Jeff ADACHI in allowing us to participate in your 10th Justice Summit and also in recognizing, I think, the important anniversary of Gideon. Our statistics in the city and county of San Francisco compared to the state and national are actually higher. 75% of our jail population is a pretrial felony population. And I think you have to put some numbers in context as to who is our inmates in San Francisco city and county jails. The population demography reflects about 56% of it is African American inside the county jail system, about 21% white, and then 15, almost 16% Latino. We have done studies in the past that show that at least a third of our jail population would be eligible for some form of pretrial release. Through programs that have been designed through pretrial release, they have been very, very effective. I know Will Leong of our shop can help underscore some of these figures. But I'll give you an idea of jail days that have been avoided, and the numbers are significant. Supervised pretrial release in the year of 2012, we had saved or avoided 43,551 jail days. For pretrial diversion in 2012, we avoided 176,427 jail days. With court accountable for homeless, the jail days saved was 8,959, and for OR, it was 105,000 in 2012. With prisoner realignment, AB 109, county sheriffs have been empowered to be able to use their discretion for early release and to use our discretion to help reroute people into alternatives to incarceration, electronic monitoring, supervised release, etc. But in San Francisco, we are experiencing a phenom that most other counties are not. We have undercrowding. Our jail maximum population is about 2,400. Our average for the last 15 months has been under 1,600 inmates per day. So we're doing a decent job as a city. And the symmetry that is lined up, I think, between public defender, district attorney, sheriff, adult probation, and a number of the other partners that have been at the table, I think for the first time in San Francisco, is finding sort of a rhythm on what we can do instead of incarcerating as a first response, potentially incarcerating as a latter response. And I like what I see in terms, I think, of the forecast of where this more progressive outlook is going. Now, I also think that 1203.01 in the Penal Code allows us, in the Board of Supervisors, through legislation, to amend the criteria for a county sheriff to be able to rewrite what that eligibility for early release or a pretrial of the existing population, even for jail systems that are not overcrowded. And I think coming out of here is a potential reform as one tries to reconcile the tension between the bail bonds industry and us looking to alternatives to incarceration and the inequities that exist of people who can't afford bail, since a high majority of them are people of color, come from disadvantaged communities, and the statistics nationally as well as state are that much more, I think, affirmed even in an enlightened city like San Francisco, which is why I think that this forum comes at an opportune time, that we should not rest on our so-called liberal laurels in San Francisco and realize that based on the demography of what exists inside our jail system and how probation then has to continue, I think, with the management, that we do want to consider, I think, some alternatives. In the Penal Code, those opportunities are provided for county governments and the Board of Supervisors to pursue legislation that empowers our local criminal justice partners to do just that.
Let me ask you, Sheriff Mirkarimi, does the sheriff right now, under particularly AB 109 realignment, have the power to release an inmate despite the fact that a judge has set bail and they are unable to pay a monetary bail?
We do. We have that through electronic monitoring or some other supervised facility. It has not been well applied, but yes.
Is that the only instance that you're given that power in, electronic monitoring? Through
AB 109?
Yeah.
Or through some kind of work furlough or some other alternative to incarceration, we are empowered to do that. But keep in mind, our AB 109 population compared to other counties has been fairly light. And I think both within incarceration and then those not incarcerated because of credit time served, adult probation in the city is doing a decent job of managing that population because we didn't send many to the state in the first place. That's giving us a chance to get a leg up in managing a sophisticated and complicated population who has been exposed to the state system to do what we can. For example, in recently launching with adult probation our reentry pod so that we can accelerate the process of reentry from the onset of incarceration with us so that we have a better exit plan so that hopefully they do not return.
Putting aside realignment, and let's just say you're dealing with somebody that's coming into the system at their arraignment, bail gets set, they're not able to post bail. Does the sheriff have any powers to release an inmate where bail has been set by a judge, pending their trial?
It depends on the classification of that inmate on a very strict case-by-case assessment, because no sheriff, I think, would want to risk certain liability based if something went awry. When I look at the failures to appear numbers, although they're not that high, but they're high enough to certainly give us pause if we do take a leap like that. And that is a path we could go down, but our classification and our confidence level would have to be at a complete optimum to make sure that there would not be any blowback from us pursuing that policy.
Let me ask our District Attorney, George Gascón. Most people believe that public safety has to be part of the evaluation that a judge engages in at the time of making a determination as to whether or not someone facing criminal charges should be released on their own recognizance. Yet many have argued eloquently that the ability to post bail doesn't reflect a person's potential threat to public safety. Your lawyers are in court every day at arraignments, arguing for the setting of monetary bail, or in some cases agreeing that a defendant should be released on their own recognizance. What are the factors that you think are most important when a district attorney is in court making that recommendation to a judge?
Yes. First of all, thanks so much for the opportunity, and to the Public Defender's Office and Jeff ADACHI for providing this forum. Let me start by saying that I believe that pretrial release should be based on three things: either risk of violence, risk of reoffending, or flight risk. I think that we have injected for many, many years a commercial value to safety that I think that needs to be reevaluated for the reasons that have been already stated. The reality is that you know, the current commercial value to the pretrial release has not only a disparate impact on minorities. I can tell you nationally 44% of Hispanics do not get to bail out. About 35–36% of African Americans do not get to bail out. Whereas white Americans generally is right around 27%. But I think that the problem that we face is that we have not come up with good predictors of risk. And often the dialogue that occurs between a judicial officer and a district attorney and a defense attorney, whether it's a public defender or private counsel, is really a discussion that is based on perhaps the individual's current offense. It may be based on the individual's history of offending, but it's very ad hoc, and there really is not a good scientific way of having a discussion around safety and around flight risk. Often many of the people that are given very high dollar bails are people that frankly the bench is looking at it and say, this is really for all intents and purposes, is really a no bail. And that's because that person is a very risky person, or at least perceived to be very risky. And I think perhaps a better response to this ought to be that if we think that this person is so risky, then there should be simply no bail. Conversely, if there is a way to evaluate that a person is not a danger to society and is likely, because of an evaluation of their personal situation, if they're likely to show up for court, then perhaps they should be released on their own recognizance. I think that, as the sheriff indicated, we in San Francisco, while we have a high level of percentage-wise of pretrial detentions as opposed to other counties, I think it's also important to recognize that part of the reason for that is because we have a very high level of alternative resolutions to incarceration on the front end. So where other counties, for instance, are barely using split sentencing under realignment, my office is actually leading the state on the use of split sentencing, which means that a lot of people are out of jail way before they would be in any other community. So these are post-sentencing people that in another county would be counting towards the total ratio of the population that here in San Francisco, they're actually in the community. There is also a large number of people that are being placed on community-based supervision, where in other communities, these people would be doing their time in incarceration. So that has a tendency to impact the ratios, because on the post-sentencing part of it, we're much more likely to release somebody into the community than many other counties are. And we believe that that has worked well for us. Our crime rates certainly have not gone up. In many areas, they're actually below many other counties, and we have been able to do so. And we're the only urban county jail in the state that actually has underpopulation. In fact, we're only one of two counties that have underpopulation, but the other ones are rural counties. So I believe that we're doing really well. Now, I do agree with the sheriff that just because we're doing well does not mean that we cannot do better. And I think that we need to do better. And I think that whether someone is going to state in custody on a pretrial setting should really be based on risk. Is either risk of violence, risk of reoffending, and an evaluation of what that reoffending would look like, or is a flight risk. I think also, at the same time that we're looking at these things, we really need to continue to push the whole concept of justice reinvestment. As we lower our cost of the criminal justice system, that funding really needs to go to places that will keep people from coming into the system in the first place. So prevention models, more money going towards education and public health is a much better investment over long periods of time than it is putting money into the criminal justice system. So I hope that as we continue to evaluate this and many other areas, that we are very clearly focused on the whole concept of justice reinvestment and where can we take money away from the criminal justice system without risking public safety, and put that money in places like our schools, our health systems, and other social services that are more likely over a long period of time to continue to reduce crime, continue to create a safe environment, and an environment where we do not necessarily have to have this large investment in the criminal justice system.
To Mr. Gascón, if we were to eliminate money bail and in effect turn over the decision as to whether or not somebody were in custody to a judge based on the factors that you believe are relevant, whether or not there's been violence, whether or not there's a likelihood of reoffending, and whether or not there's a flight risk, do you think that kind of system would likewise get accused of discriminating against the poor or racial minorities? Or do you think it would be more fair?
First of all, I think it would be more fair. I mean, if you look at the fact that, you know, Hispanics, for instance, are under the current system are 44% more likely to be held on a pretrial setting than whites, 27%. I think that we certainly can show that there's a disparity there. And then the sheriff well indicated that, you know, about 56% of his population happens to be African American. But I think that if we create a model that is based on evidence-based risk factors that can be applied to the individual and the setting of that individual, and it can be done objectively, not because of simply a judicial officer making a decision, but putting some kind of value system to those factors that are likely to impact risk, I think that we are probably going to have a much more equitable system than we have today. Having said that, I think we need to recognize that our criminal justice system is anything but equal, right? We have had a very inequitable system for many years, and there is I don't think anybody in this room would question the fact that African American, poor, and other minorities have always been more negatively impacted by the criminal justice system. And the improvement of that process is, quite frankly, a journey. I don't see it as a destination, but I think that we could have a no commercial bail system that could be done more fairly if it is done based on some clear objectives and factors that are pre-stated, so that it's not something that is just simply left to the individual judgment of a judicial officer to do so arbitrarily.
Let me ask Mr. Leong, perhaps you could tell the audience a little bit about the organization you lead and your experience with risk and needs assessment tools, or the kind of evidence-based factors that Mr. Gascón is referencing.
Thank you, ma'am. Thank you, Jeff. The San Francisco Pretrial Diversion Project has been in existence since 1976, and we're a nonprofit organization. Just by way of a little history is when we first came upon the scene in terms of pretrial release, it was heavily needs-based, which was you're really trying to wrap case management services and provide treatment, and with the idea that you're going to impact the failure to appear rate or appearing in court, and obviously recidivism. That's now jumping forward 30 years or 20 years. In the last 5 years particularly, you've heard these words. In fact, Chief Still spoke about it earlier today, evidence-based practices. In the last decade, the single biggest change in our social services has been the use now of technology. And I see it sort of akin to, and I read an article recently of like Moneyball. And what you're trying to do now is obviously base risk decisions now on much more empirically based information. As it is now, the pretrial diversion project and pretrial release is really the plumber, so to speak. The district attorney sets the policy, the sheriff sets the policy, the court sets the policy. Basically, we implement whatever it is they're trying to do. As we look at it, we've been working on an evidence-based practice in terms of risk assessment for 4 years. I think there's very exciting things that are afoot. Obviously, the major stakeholders, the district attorney, the court, the sheriff, the public defender, will all weigh in, and I think that there will be a comprehensive policy. I'm very proud to be part of San Francisco because I think that we've been here, and make no mistake that the folks we deal with are the poor folks. I mean, the folks that we get out of jail. Just to give you an idea of the scope of what we're doing, approximately 1,100 people come out of jail last year through our pretrial release programs. This year we're on target for something around 1,500 cases. Give you an idea that prior to maybe in the last 3 or 4 years, the data that's now coming in, recidivism is running around 6 or 7%. Our failure to appear rate, or the people who show up in court, is right around 94%. So we feel very proud, and the unspoken heroes in this are really the case managers and the folks who really do the grunt work. I mean, they're walking people out of jail. I mean, and we've just come out of particularly difficult 4 or 5 years, and that is the budget years with a lot of social services being cut. And really, at the end of the day, when you're talking about it, you're talking about housing, you're talking about employment, you're talking about counseling, you're talking about substance abuse. When there's not access to those services and you're trying to wrap it around. Coming full circle today and answer really maybe more specifically to Matt's question, the issue really is how do you now relate the risk assessment, or as the district attorney talks about, a much more refined instrument. I totally agree that there has to be this instrument that assesses risk, and whereas before, 20 years ago, we were much more needs-based, there's a risk assessment side. And what you have to do, and what you realize, it's leveraging limited resources. We simply must focus our energies now, and I know the sheriff has beat that in my head many times. You've got to focus your services and get, obviously the return. And that's really where the technology comes in. There have been tremendous advances I've seen in the last 5 or 10 years. Every day, our office is changing. But I fully expect that as is happening now, our case managers, the challenge for our case managers, as in Moneyball, they're going to have to adapt to looking at best practices in the same way. But you can't substitute great case management and social services. And that's really how it wraps into what we do.
You know, before I get to Ms. DeWitt, I want to give Professor Simon a chance to say a few words. I'm wondering, Professor, if you could contextualize this discussion historically, and I'm very curious as to whether or not there's ever been a, let's say, a large or successful movement in this state towards the elimination of money bail.
Oh, well, now you're gonna stump me by starting off with an empirical question I don't have a quick answer to. But let me talk to the more general context. And first of all, I'm very honored to sit here with so many distinguished public servants and professionals. I have tenure, so let me be blunt. We are speaking not at any time, but after a period of nearly 40 years of building a system that many of us call mass incarceration, in which we have huge numbers of people locked up, who most people now agree, many of whom don't need to be locked up. And it was done for a reason, and that was to, I think, to provide public safety. At least that was the public justification for it. And that's one of the reasons I see bail as so critical. It's not a sexy topic. It's one of the reasons it's kind of languished for decades compared to the death penalty or 3 strikes. It seems like a rather minor thing to deny somebody bail, but it's really the beginning of a chain that leads to personal incarceration and collectively to mass incarceration. And I would suggest to you that what happened, beginning with really the failure of the bail reform effort of the 60s to achieve a constitutional right to bail, and I'd like to come back to that because personally I think if the Supreme Court can find a personal right to bear arms in the Second Amendment, they can certainly find a right to bail in the Eighth Amendment, which says excessive bail shall not be required. We can talk about what excessive bail could possibly have meant to the framers. But I think what's so dangerous about that moment, and it came to a peak came to the surface in the bail reform, so-called Bail Reform Act of 1984, the federal law, the birth of preventive detention, which was once thought to be clearly unconstitutional, and then became a public good that changed our whole view of the system. And I would argue that we now live in a system of preemptive justice, where we don't wait for crimes to be committed. We've incarcerated hundreds of thousands of people on the theory, not that the crime they committed was so bad, but that they'll commit other crimes in the future. And I would say if we all now agree, or at least many of us agree, with Justice Kennedy, that the result has been a prison system that is barbaric, that doesn't belong in a civilized society, that requires serious atonement by the public agencies that created it. They use the word torture in that opinion, and even my colleague John Yoo, I think, would recognize many of the things done in California's prisons to meet that. Let me say why I'm so nervous about the risk. It's always so reasonable to see risk as the way out of these. I don't think I need to remind anyone in this room that between 1942 and 1945, an entire portion of our population was incarcerated on the grounds of risk, a risk they posed somehow to our national security. Not an iota of evidence ever supported it, but nobody was ever held accountable for it either. It seems to me that if you look hard at the way we assess risk, what you see is that race and class shows up again and again and again, all right? So if having a drug arrest is a risk factor, well, we know that is incredibly racialized experience in America. Your odds of being a drug arrestee as a Berkeley undergraduate, smoking as much dope as you can get your hands on, very low, right? So we know that this is a deeply racially and class-based allocation. So when you build risk into the system, and you think you're getting away from the injustices of money bail, you may not be. Two more sentences. I think one of the reasons that this system has been so effective is not really the greed of the bail bond industry, but this sort of marriage of convenience between public safety and profit, right? It's the same logic that we see in mass incarceration as well, where judges feel they're doing the right thing for the community by raising monetary bail levels, and where, of course, a bail bonds industry is going to respond to that. Now, I do think the kind of work that Will does is the answer, because at the end of the day, the right kind of community ties, investigations, and services to make those real when they're not, is risk reduction, right? We have this image that risk is about individuals, bad individuals that are out there, and we can find them and preemptively lock them up, we'll be safer. But what we've learned, especially from the New York City experiment in recent years, is that we can prevent crime in real time, not based on who the people are, but the way police are deployed, how we organize our prevention efforts. So I think there's a lot of reason to be excited and optimistic right now. I would not want to see us double down on a sort of risk prevention mentality in bail.
Let me ask you. Professor Simon, let me ask you a follow-up. I want to get an idea of what a system that you're advocating would look like. I mean, let's say you've got the arraignment for somebody in a case alleging violence. Maybe it's an armed robbery, or maybe it's a sexual assault of some kind. Are you comfortable with someone having a right to being released on their own recognizance under the theory that the police should do their work and make sure that person doesn't commit other offenses, and that it's not legitimate to make that consideration at the time of a bail assessment?
I think that is my view. I mean, I think through slow steps, we accumulated a system which incarcerates tons of minor offenders and the goal of broad public safety, and has then lost its ability to address serious crime in a focused way. The way to sort of correct that is not by sort of tossing out the presumption of innocence or constitutional rights that we have in order to sort of make up for the mistakes we've made. I think that what we ought to do is toss out the various low-level crimes that we fill our jails too often with, not necessarily in this city, but in many parts of this state. And that with that additional bandwidth for focus and resources in the police department, we do focus on the areas and the activities that generate crime and focus less on preemptively locking people up, because in many cases, we're either punishing the person ahead of their trial, in which case, and after all, less than 3% of Americans accused of a crime even receive a trial at this point in what we like to think of as our justice system. That is a model of risk prevention that has now been tried for 40 years, and I think it's failed.
Let me ask our law enforcement representatives here, Sheriff Mirkarimi and our District Attorney, George Gascon. Do you agree with Professor Simon? Could we
don't have tenure.
Could we have a system? Could we have a system that didn't look to the likelihood of reoffense or what the charge was, but simply looked at whether or not somebody was coming back to court?
Go ahead. I can certainly start.
We've been through this. Yes, I think we could experiment, and I was referencing earlier that there has to be all stakeholders on the same page, and that while a very little window is given to the Sheriff's Department to be able to reclassify and allow somebody certainly to be released pre-trial, supervised, that is for the nonviolent offense for the most part. In fact, high majority of the time. Even a few misdemeanors are in our jail system. But if there was criteria that was changed, not just based on discretion by the sheriff or just by the district attorney, but the criterion that I think would be reconfigured and acknowledged so that it becomes part of law in the city and county of San Francisco, that to me then affirms our commitment to what then this experiment would look like, to make it a product of sort of a discretionary act by those that are just elected. So goes, I think, with that experiment, the tentativeness of what this commitment would actually be, which is why I'd like to see the mayor and the board of supervisors join us in exploring what those reforms could possibly really mean to us.
Our district attorney.
I just want to start by saying I recognize the fear, because I think it's a fear, not even a concern, that Professor Simon has about creating a risk assessment tool that could be manipulated to use low-level offenses, drug offenses, or many other factors that could, end up having a disparate impact, much like we have today with a commercial bail system. But I believe that there's actually a way that we can create validated risk assessment tools that would actually look at specifically at the areas of concern, whether we're talking about the likelihood for reoffending in a violent way or the likelihood of not showing up for court. I think that there are systems in place already that have shown a tremendous amount of promise, and I believe that we can continue to go down that path to create that type of a tool that will avoid, to the greatest extent possible, picking on those things that, quite frankly, large numbers of people were incarcerated in the past or still are in many places, and taking those away, but looking at the real risk. we know there are some people that are, for a variety of reasons, are going to be inherently violent. And for those people, unfortunately, the only thing that is going to work at that point in time is going to be incapacitation. And there's the ability to predict that with a high degree of certainty and still move away from factors that are likely to be focusing on somebody's race or gender. So I believe that those are valid tools that can be developed, and there is a lot of knowledge based on that. I think also it is important for us to look at the possibility of skipping your due date in court. I think that part of the validity and the credibility of the court system is based on people agreeing to show up and showing up. And I think, again, there are many factors, and many of them that are based on, evidence that has been proven about people that are likely to come back to court and show up and people that are not. Now, clearly, services like Will has are the kind of services that can take somebody that could be right on the edge, and they can make all the difference in the world. And we should be focusing and putting those people on those services. But again, we can create a risk assessment tool that would take into consideration the fact that we will have very strong support mechanism and supervision through a pretrial service and ensure that that person will return. So I don't believe that risk assessment is mutually exclusive with fairness, but I fully understand your concern. Certainly the history of the criminal justice system has not been one that gives a lot of comfort, but I don't believe that we should be precluded moving forward, especially in a community like ours, where I believe that we have a tremendous opportunity for exploration and the will to do so and to do it right, to not continue to set the trail and show that this can be done and can be done thoughtfully.
Sheriff Mirkarimi,
just want to add a fact that many here I think will know this, but general population does not, that last year in 2012, we memorialized the Sheriff's Department taking over bail because of the stress of the court system that no longer can really process the bail due to the budget hits that the court system was taking. And we took a snapshot of how much bail had been transacted, over 2,500 transactions in 2012. It comes out to about $100 million of bail that had been exchanged in the year 2012 through those number of transactions. Now, coming through us, the process is that you pay, your assurity or your entire bail. Going through the bail bonds industry, that 10% represents $10 million.
Let me make an announcement that we are going to take questions from the audience. If you want to ask one, there are cards. You can signal to Amy Bevan here, who will hand you one, and we'd love to hear your questions. Ms. DeWitt, it's been a while since you've had the podium or the mic. There's been a lot said. I'm wondering, when you hear this talk about eliminating money bail system, I mean, is this something that can realistically happen, or do you think that if we were actually to achieve that, there'd be a move to reinstate what your organization does?
Well, let me first, thank you, Matt. Let me first say I feel like a minority among the panel, and but I'm not overwhelmed by it. I think we have a little misconception here, and what we forget all along is the public, the taxpayers. The bail industry provides a service to the criminal justice system, and it has for over 200 years here in the United States. And we've done our job without any cost to the taxpayers. If someone flees, we bring them back. None of this burden is on the taxpayers. And what I see happening is, and I've had discussions with the ACLU and pretrial and so on, is that it's not a cookie cutter type situation, or this risk assessment is a one thing fits all. Bail is very personal. And to have a policy or a government entity responsible for arresting you, responsible for adjudicating your case, responsible for the sentencing part of it, and there's no checks and balance, there's no outsider involved with this. I've sat in Los Angeles and waited with the sheriff's department for someone who has to get to his job the next day or he'd lose his job, waiting on a pretrial OR release. 25 hours, 36 hours later, he's still in custody when he could have been bailed out through corporate bail. Our industry brings to the state of California revenues in excess anywhere from 11 to, and I don't know the figures of the sheriffs, but 11 to 20 million dollars to state revenues. And what I'm hearing is that they want to, this movement is to chop us off completely. And I say no, we need to coexist. There's a place for corporate surety bail, there's a place for pretrial. But up until the last year, we really have not been invited to the table, and this kind of dialogue is very important. You need to hear what we have to say. There's a misconception also that GPS monitoring, release someone on an OR and GPS monitoring. Who's going to pay for that? The taxpayers or the defendant? Generally, I hear the models are the defendant. And so you're talking about, well, does he want to go to work with an ankle monitor on his leg, or does he want to go out with a surety bond and so that he doesn't have the stigma? I mean, you're innocent until proven guilty. The other last thing I want to say is about this pretrial incarceration figures, the number of people in custody. They're not there because the defendant or the family can't negotiate with the bail agent their release. Most of those, and I don't know the numbers because it's very hard to get numbers. The transparency is not there on pretrial release figures. But these people are in custody, and they, you know, I lost my train of thought. That's a senior moment. I was going to make a good point, and I'm sorry.
Afternoon.
I apologize about. I was going to make a point there, and
well, let me go to your neighbor, because I want to actually find out if you're in the minority. Ms. McCracken, does your organization support the elimination of money bail, or are you focused on other reforms?
We are focused on other reforms. We really advocate for the expansion or implementation of pretrial services, and there's great demand for that across the state of California. The Criminal Justice Institute has been just recently awarded only 2 counties technical assistance services in implementing pretrial services, but the demand was from 20 counties to have those technical assistance services. So there's a great interest from California counties to look to this very deliberate intervention to rethink and retool their approach to their local criminal justice system. And I think San Francisco and Santa Cruz County as well are really great examples, because they are both counties that 30 years ago had overcrowded jails. And the local justice administrators made a very deliberate attempt to implement programming such as pretrial services to really change their system. And I think that it has allowed San Francisco and Santa Cruz to both be ahead of the game when realignment hit, to be better prepared to manage this increased responsibility. So I think there are 2 kind of case studies that we can really look to and look for peer support from our local justice administrators to help other counties implement such services.
Mr. Leong, I'm wondering if you could address Professor Simon's point that a risk assessment tool can have in it a built-in kind of discriminatory component. You know,
I want to just add in there, thank you, Matt, just to add into what the district attorney was saying. We're currently validating our instrument, and the 6, half a dozen factors they're looking at include the current charge, a felony, being unemployed, history of drug abuse, and having a pending case, which I think is perhaps much different than, say, 10 years ago. And we're validating this information now in terms of comparing it to the mounds of data we have. If anything, if there are any volunteer researchers out there who want to sign, it really requires a lot of work and scrutiny. But I think it echoes what the district attorney is saying. We're mindful of that the jails have been disproportionately African American, Hispanic. We're mindful of the fact that it's really been poor folks that we've been dealing with. And, It's obviously that, our basis, our history is really coming from the social service side. But I just want to reiterate that those are really the factors that the risk assessment tool is starting to look at and zero in on pretrial release.
Professor Simon, historically in California, was there a right to bail movement at one time?
Well, I wouldn't call it a movement. I think, bail has always sort of existed under the surface. I think in the 60s and early 70s, at a time of tremendous interest in due process for prisoners, in my teacher, Caleb Foote, the late, great Bolt professor who had actually campaigned with Dorothea Lange against the Japanese internment, turned his attention to bail in the 1950s, argued there was a constitutional right to bail when he came out to California in the 1960s. I can't say there was really a grassroots movement for it, but I think if you look at that period, when we passed things like the Lanterman Petra Short Act to deinstitutionalize the people who were warehoused in mental hospitals and other initiatives, the state was looking at trying to break down these very discriminatory patterns that had historically focused on certain communities. So I think there was a moment of that. Unfortunately, it was caught up in a moment of extraordinary fear of crime. I'm old enough to remember the mood in this state, even in the late 70s, as the homicide rate continued to go up. In many ways, it was very much like the mentality after 9/11, a sense of something has to be done. And of course, in times like that, we tend to throw dignity under the bus in the name of risk prevention. But it usually comes back to bite us. And I do want to say, though, that whether we're talking about risk assessment, money bail, or classic pretrial release considerations, poverty and therefore race are likely to be discriminatorily impacted, and that we really have to have a proactive effort to disembed that racial effect if we want to change it.
Absolutely.
Let me take a question from the audience. Professor Simon, why don't you take a first crack at it? Money bail system often taps relatives' assets. Then the relatives are motivated to help locate the fugitive if they fail to appear. What would motivate relatives to rat out the fugitive if not financial self-interest / forfeiture? In other words, I think what the question is getting at is that sometimes having to post bail can cause the community around the accused to get more involved in their life and take an active role during the pendency of the charges, or if you've got the situation of a fugitive perhaps getting involved. Your thoughts?
Yeah, well, I like the idea actually of community engagement as a way to both reduce risk and to reduce the chances, increase the chances that somebody's going to both participate in the justice system and benefit from it. On the other hand, I don't buy necessarily, or at least I'd like to see some evidence that taking away somebody's home is therefore going to incentivize them to help lock their son up for, it might, but I'd like to see the evidence that it does. It might incentivize bail bonds people to be good detectives and find offenders, but I think we could find a way to do that without necessarily tying people's assets to that.
Sure. Ms. DeWitt, you want to get in
I
on
just
that?
want to respond to a real misconception, again, about the financial taking of someone's property, and that's like the norm with the bail industry. That is not. I mean, I myself personally have been in business for 41 years and never taken one single home. We do rely on our detective skills. We do rely on our bounty hunter skills to get our defendant and get them back into custody, and that's what we're good at. So I think the involvement of relatives, friends, co-workers, employers, all that is a mix that we use. Our risk assessment tool has been very effective. And so I don't think that creating an atmosphere that do away with corporate bail, surety bail is the answer. It's not. We have to work in conjunction with the pretrial release system, with the law enforcement, with the judicial system, to coexist in the criminal justice system, and we're part of it. I think we're part of it. I see that we will be a part of it for years.
We've got a second question here. I'm going to ask it. If someone qualifies for release, isn't it inherently unfair that this person remains incarcerated because of an inability to post bail? I guess if somebody qualifies for release, they don't have to post bail, right? So they would be able to get released. Are there instances where somebody would likely, let me ask it differently. I've been in court before where a judge is maybe looking at someone charged with a crime that they would typically grant a release on, but they then see a defendant that they think have other issues going on. Maybe they're barefooted or they don't have a place that they're living, and they might get someone like Will Leong, your organization, involved to help supervise. Is that appropriate, or is that really violating somebody's right not to have the oversight of the court or criminal justice system? Will?
The common how supervised pretrial release came about was really during the jail overcrowding. And there are cases where, specific cases, getting a homeless individual. There's a group of case managers managed by Ali Riker called the Court Accountable Homeless Services. It targets homeless individuals. Mental health cases have been very common. That traditionally cases that might have been OR, that the court is looking for extra supervision. But again, as you might imagine, the resources are severely taxed. And during the budget difficulties of the last few years, the ability to manage large numbers. We're talking, for example, homeless individuals. We see 30 individuals at any one given time. That's the active caseload, and it's really driven by that.
I've got a question from our public defender for the law enforcement officials here. What reforms can you commit to at this point to reduce pretrial detention population? Shall we start with Sheriff Mirkarimi or our district attorney? Who would like to take that first?
I'll just reiterate the strategy that I think San Francisco should seriously consider legislating a new criteria. That is what the penal code has empowered us to do. This is not only through the AB 109 population, but general population. And we could start right away by corralling a number of the legislators in City Hall to get behind this effort completely. I also suggest budgetary-wise, pretrial, as Will represents, is not funded enough. Frankly, and our ability to, I think, really discharge in a supervised capacity so that there is an alternative to incarceration is something that the city should put on a higher pecking order, since it costs about $50,000 a year to incarcerate somebody. When I look at the collaborative court models, when we look at the number of pretrial supervisory models that we've been talking about here, they really are a fraction of the cost. And I don't quite think that we have that system down as fluidly as we would like, because I believe many other people are eligible for these programs that cannot make it. And that requires pretrial to be able to staff and have expanded capacity to take care of this population.
And George, we're going to give you the last word because we're pretty much at our time.
Well, I appreciate it. Well, you know, I think that we are already on the way. I mean, the reality is that several of us here are members of the Sentencing Commission, including our public defender, Ms. McCracken, Sheriff Mirkarimi, and myself. And this is an effort that started last year, and the goal is a 2-year process where we're going to be looking at sentencing reform and looking for evidence-based practices to determine when and what type of incarceration levels are appropriate, and certainly pretrial detention is part of the mix. I think that I go back to what I stated earlier. I believe that pretrial custody should be based on appropriate, and I want to underline appropriate, risk assessment tools that are going to be race neutral, that are going to be gender neutral, that are going to be socially neutral, but are going to assess risk of reoffending, risk of violence, risk of not showing up for court. I believe that that is an achievable goal, and I believe that the Sentencing Commission is really a very good place. We have excellent researchers at our disposal. We have a 2-year plan, and we have basically every component of the criminal justice system as well as the community is represented in this process. So I hope that actually we will come up with a good pretrial releasing process.
I want to thank all the panelists for participating, and thank you all for attending. I think our public defender is going to make some closing remarks.
Thank you. It's a great tour.
In closing, I want to thank all of you for attending this year's Justice Summit. As you heard, we have many, many challenges in terms of areas that we need to look at and improve upon, and we look to the community for your support. The 50th anniversary of Gideon will continue throughout this year. For more information about the Gideon case or activities in your community, please visit www.gideonslegacy.com. .org. It's gideonslegacy.org. We will also be posting more information on our website at sfpublicdefender.org as there are new developments throughout this year. I also want to invite you all to attend a very special event we're having on May 9th. Sister Helen Prégine will be here in San Francisco. She's a very well-known death penalty advocate. She was played by Susan Sarandon in Dead Men Walking, and that's going to be a free event at Temple Emmanuel, again, 6 p.m. on May 9th. So I'd like to thank all of our panelists, all of the volunteers and supporters who made this event today possible, and of course, all of you for attending. So thank you, and have a good evening.
No, I wasn't very serious. I heard it was very good.
Thank you. I tried.
You know, I don't have one, but if you Google Jonathan Simon, I come right up.
I know, it's all good. I tried to buttress you guys as much.